He asked in an aspirational way. He went on to say, asking is not speech. It's not action. That's the heart of this, right? Speech versus action. Does that defense fly here?
Not at all. I'm not aware of the aspirational defense or the free speech defense to to a gang leader saying to two of his subordinates, "I need you two to please rob a bank for me," and they do it. That's aspirational, but it leads to a crime, and that's exactly what Trump did with Pence.
So that was someone by the name of Ty Cobb, who was once the top White House lawyer in the Trump administration. And that video was recorded. That interview took place shortly after the Washington, D.C. criminal indictment for Trump's attempt to overthrow the results of the 2020 election was unsealed. Then Ty Cobb gave that interview. Remember at that time, what was Ty Cobb responding to? Donald Trump and his lawyers saying they have this absolute immunity defense. And back then, Ty Cobb was mocking it. Now, Ty Cobb and a group of others, top lawyers, top former leaders in the Republican Party, top former United States attorneys, Republican and Democrats, but top prosecutors, mostly Republicans, have come together and filed an amicus brief. This is a different group filing this amicus brief to the D.C. Circuit Court of Appeals, all coming together saying Donald Trump's absolute presidential immunity defense is entirely without merit. I'm going to read you just some of the names of the people who have signed on to this amicus brief so you see the firepower here. And just to remind you what an amicus brief is, an amicus brief or an amici refers to a friend of the court brief. It's a Latin term, but it means friend of the court brief. And these are briefs submitted by outside groups or third parties that are intended to persuade a court, usually whether it's the Supreme Court or a court of appeals. It isn't, like precedent. It's not like the courts of appeals or the Supreme Court has to follow what the amicus brief says, or they don't even have to necessarily accept it or read it. But oftentimes when it comes from influential groups, especially like this, where you have the former top lawyers, especially former top Republican lawyers who have dealt with the issue of executive authority, because these are all such credible and respected people, courts will look at them and read them and look to them for guidance sometimes, and it's a powerful group of people. Never before have you seen so many people from both political parties joining forces and submitting different types of amicus briefs like this. This is the latest example of it. And so, as I mentioned, you had Ty Cobb, the former White House lawyer for Donald Trump, submitting a brief against Donald Trump, the person who would be the one to essentially assert absolute presidential immunity. That's why it's so significant that Ty Cobb is the one doing it. The person who would try to defend Article 2 power is basically saying in this brief, yeah, I was there when we were in office. There's no such thing as absolute presidential immunity. Let's take a look at some of the other names. Then I want to go through some of the arguments that these top lawyers, top former prosecutors have all joined together to say that Trump is wrong. You've got Bradford Burnson, associate counsel to George W. Bush. You've got Gregory Brower, who's a United States attorney for the District of Nevada in the George W. Bush and Obama administration. You've got Tom Campbell, a Republican member of the House of Representatives from California, who's now works at a law firm and is a distinguished law professor at Chapman University. Ty Cobb, who I just mentioned. You have Tom Coleman, a former Republican member of Congress. George Conway, of course, we all know George Conway here. John Farmer Jr., the New Jersey Attorney General appointed by Republican Christine Todd Whitman. You've got Patrick Fitzgerald, Remember Patrick Fitzgerald? That was one of the top United States attorneys in the Bush and Obama administrations in the Northern District of Illinois. You got William Crystal, who's been on the show. You got Philip LaCavera, the Deputy Solicitor General in the Nixon administration. John McKay, the United States Attorney for the Western District of Washington under the George W. Bush administration. Trevor Potter served as the chairman of the Federal Elections Commission and is appointed by George H.W. Bush. Claudine Schneider, United States House of Representatives Republican. Fern Smith, a judge for the District Court for the Northern District of California. Olivia Troy, who's been on the show before, who was in the Trump administration. William Weld, former governor of Massachusetts and also United States Attorney for the District of Massachusetts in the Reagan administration. I mean, look at that firepower. So this is why I always say, like, these issues are not like Democrat versus Republican. Mostly all of those people who I listed were Republicans and top Republicans who are saying, this is about democracy. This isn't a political issue. The only people who are politicizing this is the modern day MAGA Republican Party, which has taken over the Republican Party. That joined with Fox and all this right-wing media, they act like this is some political thing, that it's the Democrats who feel that there is no absolute immunity and the Republican. No, that's not the way it is. There is no such thing as absolute presidential immunity for former presidents. And such a precedent would mean that our democracy is done. Because essentially it's saying that a former president could have engaged in any conduct, criminal conduct, and be immune for it for trying to overthrow the results of a free and fair election. Now, one of the things that I found very interesting as I read this amicus brief submitted by all of those incredible individuals is their argument basically mirrored the two-step analysis that we've been talking about on Legal AF. Almost looks like it's a script from Legal AF. It isn't, of course, but that's kind of how spot on the arguments we had here on Legal AF and the analysis we've been doing in these hot takes, right? Analysis 1, the Constitution's history, text, and structure does not support absolute presidential immunity for former presidents. The doctrine doesn't exist. Step 2, even if there is some sort of limited absolute presidential immunity in criminal cases, because Donald Trump's conduct here was outside the outer perimeter, because it involved elections, because it involved campaigning, because it involved interfering with the states' rights to oversee their elections, that can never be within the outer perimeter of legitimate presidential authority. A la, which case have we been talking about here on MeidasTouch Network and Legal AF over and over again? Yes, the Blassingame case by the D.C. Circuit Court of Appeals on December 1, where the D.C. Circuit Court of Appeals held that Donald Trump could be liable for the conduct relating to the January 6th insurrection, and that he was not entitled to absolute presidential immunity for civil cases, for civil monetary damages, because the conduct involved elections and campaigning, and it was outside the outer scope or the outer perimeter of presidential authority. So it's that two-step analysis. 1, the doctrine of absolute presidential immunity doesn't exist in criminal cases for former presidents. 2, even if it does exist, Blassingame states this type of conduct falls outside the outer perimeter of any immunity. Let's just take a look at the summary of the argument here by these distinguished lawyers. It says, defendant, the former President Donald Trump, asks this court to grant him immunity from federal criminal prosecution for all official acts he took while he occupied the presidency. The district court concluded that his extraordinary request has no basis in our constitutional text, structure, or history, and Amici agree. Defendant's petition cannot be squared with the Constitution's text or history. He repeatedly invokes implied separation of powers principles, contending that the imposition of criminal liability on him would unduly impair the executive branch. but it is Trump's claimed immunity, not his prosecution, that would undermine those principles. The immunity he seeks would severely impair the ability of the current president, in whom all executive powers are vested, to take care that Congress's laws prescribing obstruction of federal elections are faithfully executed. And by asking the judicial branch to fashion a sweeping, atextual immunity from whole cloth, he draws the judiciary and the executive into conflict. 2, even if the former president had some limited immunity from criminal prosecution, it cannot conceivably cover the acts alleged here. First, many of the acts alleged in the indictment plainly constitute campaign activities that would not be protected even if there were some official duty immunity from criminal prosecution. Second, defendants' alleged acts fall far outside any core presidential duty or function. Many of the acts alleged plainly constitute electioneering, and in any event, the Constitution entrusts presidential elections to the states and the Congress, not the president. Indeed, the alleged criminal activity here raises a uniquely dangerous constitutional threat. The chief executive using his purported authority to violate the executive vesting clause, United States Constitution, Article 2, Section 1, Clause 1, and remain in power beyond his legitimate term. Such activity threatens our constitutional structure at its core, and by its very nature eviscerates one of the primary constitutional checks on presidential misconduct, rebuke by the people at the ballot box. And there you have, I think, a very powerful argument there. If I can quibble with one thing here, I probably would have started the first paragraph slightly different, where it says, defendant, former President Trump, asked this court to grant him immunity from federal criminal prosecution for all official acts he took while he occupied the presidency. I think I would just frame that differently. I think I would just say, defendant, former President Trump, asks this court to grant him immunity from federal criminal prosecution for all of the conduct alleged in the Washington, D.C. federal criminal indictment. I probably would have used that language rather than all official acts he took while he occupied the presidency, because I think by saying all official acts he used while occupying the presidency, you're buying into Trump's language that those acts constitute official acts, which you then go on in the brief, as you saw in the later paragraph I read, to say those actually don't constitute official acts. Those are the acts that states are entrusted with and Congress is, and not the executive. So I would have just changed that first sentence, but it doesn't matter, because this isn't special counsel Jack Smith's brief. This is the Amicus brief meant to bolster the argument by special counsel Jack Smith. And I think it's a very well done brief. And just the fact, though, that you have all of these great legal minds together, many top Republican lawyers all joining, including the White House counsel in Ty Cobb, the former White House counsel, you don't get much more powerful of a statement than that. Tell me what you think in the comments below. Hit that thumbs up button when you hit that like button. That helps these videos get to more people. And hit subscribe, okay? It's free to subscribe. We're on our way to 2 million subscribers. So please subscribe, spread these videos, share these videos, tell other people at MeidasTouch about MeidasTouch Network. And you could also check us out at patreon.com/MeidasTouch, and have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.